I had the difficult task to speak about enforcement of geographical indication in Southeast Asia, which is quite a big numbers of countries, of course, to protect GI producers and consumers. So the presentation will be in 4 parts. I will first give a short introduction. After we look at what are the infringements, what are the misuses which are prohibited, meaning what is the scope of protection of geographical indications. Then we'll have a short overview of the enforcement actors and actions in some countries of ASEAN. And the last part of the presentation will be on the challenges for enforcing GIs in ASEAN countries and some recommendations for further discussion. So as you all know, there's a very dynamic protection of geographical indications in Asian countries since the TRIPS agreement, widely through geographical indication treasury systems in 8 out of the 10 countries of ASEAN. And then you have the figures of the numbers of GIs registered in Asian countries, including those registered in EU. So just talking about Vietnam, where I had the chance to work for 6 years, indeed, there's one GI registered in the EU, which can benefit for the protection that just before Mr. Benito has presented, is the Nyokmam from Phuket. And also a very increasing trend is the signature of those bilateral agreements, which include a chapter on geographical indications. And you see there are many in Asia, of course, signed by the European Union with Asian countries, as Mr. CIRAD presented in his introduction, but also signed between countries in ASEAN themselves. You have the ASEAN-Japan trade agreement, also with the countries in other areas of the world, like Vietnam, Mexico. And looking at the enforcement, it's important also to see what are the scope of protection depending on each country's legal framework, which depends on the signature of other international agreements, such as the Geneva Act of the Lisbon Agreement, which provides for very high protection of geographical indications against frauds and imitations and infringement. And actually, Cambodia is the first signatory country of the Geneva Act, so country from Asia. Here are just some pictures to show some examples of geographical indications from Asian countries. And on the right part of the slide, you see the national logo, which have been enacted by the majority of countries in ASEAN to be used to all GI protected in their country, usually in addition to the product logo. We'll see that because it's also an issue. And here you have example of this Nyokmam fish sauce from Phuket, the compote pepper, which is a very famous GI from ASEAN, then the beef from Kobe in Japan, you have coffee from Indonesia, the Gayo coffee also registered in the EU, Darjeeling tea, and handicraft product. You see the silk, Lamphun brocade silk from Thailand. So of course, why is it important to have control of geographical indication? That was very well explained by Dr. Bellatori, that if there is no control of the use of the GI on products that do not comply with the book of specifications, then all the efforts to protect the reputation of the product are jeopardized. And we saw it's quite a big economic issue when you have a high amount of infringement of the geographical indications. Here, I would just like to highlight that the book of specifications are the technical rules regarding the characteristics of the product, the method of production, the geographical area, but also the labeling rules that are mandatory for each product to be when it is registered as a geographical indication. So here, when we speak about control on the market, enforcement, it's really the control after the product is put into the market, which is different from the control that is implemented before the product is sent on the market. That is the control at producers, processors place, or the first trader sites. And it's by different actors, certification body usually or public bodies doing this control at the producer's place. here today we are really talking about the controls on the market, which is the control at the retailer's place, including in internet. And we saw there was a lot of infringement on internet, but it also includes the legal proceedings against those infringements that can be brought in front of courts, and the opposition against trademark applications if they are infringing geographical indications or misusing geographical indications. So that would be the three actions we will look at this morning. So just a general figure about the cost of infringement in the EU. So there was a report in 2016 from a survey done on 100,000 products in 17 member states of the European Union. That represents more than 80% of the EU GI market. And this survey has come out with the result that frauds of geographical indications represent almost 10% of the value of the GI product markets in the EU. So it's really important, and this is why countries like Italy, I mean, we had this excellent presentation, has tackled the issue with big means, trying really to fight against those frauds, because the economic impact is important, and 10% of the market value is frauds. Then if we look at some general data about frauds and infringement in ASEAN countries, well, it's quite difficult to gather those data. Probably some of the participants or speakers have the data for their own countries. I just had some data from one particular product, which is not yet registered as a GI in Vietnam, but that will be protected following the EU-Vietnam Free Trade Agreement, which says that around 10% of the market place that were targeted, that were surveyed by the Producers Association for Champagne in 2018, were selling products not coming from Champagne. So we also have this amount of 10%, which is quite similar to what we have found in the EU. So we could assess that more or less the frauds in geographical indications represent 10% of the market. But then the big difference between EU and ASEAN is that there is not a single system for geographical indication in ASEAN. There is not a single regulation with the same system for the 10 countries in ASEAN. So the enforcement is at country level, of course, but what is needed to stress out is that this enforcement is according to the national legal framework of each country of the ASEAN, or, and this makes the things complex, according to the provisions of free trade agreements for the foreign geographical indication that are protected in this particular country of ASEAN and which are included in the FTA. So you have a kind of different scope of protection even within one country. The European geographical indications protected in the EU-Vietnam FTA will have a different scope of protection than a European geographical indication that will be directly registered in Vietnam, because the scope of protection in the FTA is different than the scope of protection in the national Vietnamese legislation. So it means that in each country you have a different scope of protection. So we need to look at it carefully. What is infringement? What are the misuses prohibited? And this is a country by country situation. And of course, the enforcement actors are different in every country. So just let's look first at the scope of protection, as this is quite an issue in ASEAN countries which have different systems. First, what is the object of protection? Of course, the name which is registered as the GI, the geographical indication protects the name. So first is the protection of the name. But the specification or the book of specifications also includes some labeling rules, which depend on each geographical indication. So, for example, the labeling rule can include mandatory use of the product logo, national GI logo, and some traceability information. Let's look at 3 cases from ASEAN countries. You see the compote pepper, GI from Cambodia. The name of the GI is compote pepper, and the labeling rules which are set up in the specification of the GI in Cambodia, but also in Vietnam and in the EU, as this, and in Thailand, and this GI is registered also in Thailand, provides that it is mandatory to use the product logo compote paper. You see the red and the black logo, the national Cambodian GI logo. It also provides that the name Poire for the compote, this is the French translation, or any translation, shall be written with a font size bigger than any other letters in the packaging. And moreover, there's a need to show the individual batch number on the packaging. So all these are the rules that the enforcement authorities need to check. Besides, I mean, beyond only checking the content of the specification, which is the characteristics of the product, geographical area of origin. Then if you look at another example in Asia for Nyok Mam Phu Quoc, of course, the protection is on the name, Nyok Mam Phu Quoc. Well, here it's mainly Phu Quoc because the Vietnamese law only protects the geographical name without the product. And here the labeling rules provides that it is mandatory to use the label you see in the table, which means that 1/3 of the label is the same for any producer. And it has to be followed, which has the product logo Phu Quoc, you see with the shape of the island on the bottom, and then the same color, yellow and red, has to be used by all manufacturers of fish sauce. That is mandatory labeling. And then the last case from Thailand, that's a handicraft product. So here you have the lampoon brocade Thai silk, and the labeling rule says that it's mandatory to use the national GI Thai logo, plus the number of the GI and some information about the product. So this means all those details, all those aspects have to be controlled when doing inspections and checks on the market by enforcement authorities. So what I would like here to really stress is that, of course, the enforcement authorities will need to control that product complying with the characteristics and geographical area of the specification are respecting the labeling rule. I would say this is maybe the easiest, but there's also really the need to control any product, even if they only use the GI name, which in that particular examples is compote paper, Nyok Mam Phu Quoc, or lampoon brocade Thai silk. It's really important to resist to the temptation of controlling only the products using the logos, because GI is first of all the protection of a name. But we see in some countries that facing the big difficulties of controlling all the products in the markets, there is some temptation to consider in priority controlling the products that are using the logo, whether the product logo or the national GI logo, and to, in a way, consider that the mere use of the name is not a problem. That's, compote Nyok Mam Phu Quoc, if it is used without the logo, it's almost an authorized use because they are not infringing the logo. But here I would really like to stress out that the protection is, of course, on those logos because they are part of the labeling rules, but it's also on the name. So just the use of the name is already a fraud, is already an infringement. It means a lot of work for the enforcement authorities because the name is widely used, sometimes by producer not knowing there is a geographical indication. So it's much more difficult to enforce the rights when you have had a name already used in the markets without sufficient awareness that there's a geographical indication, and therefore some rules to be followed. Then looking at the scope of protection, what is very important in ASEAN countries is that actually there's quite a big heterogeneity depending on the countries. So here we have more or less, broadly speaking, 3 levels of protection. So the low protection level, which is the TRIPS standard, TRIPS basic protection, then the high protection, the additional protection provided by TRIPS, and what I call the super high protection, which is the one under the Geneva Act of the Lisbon system. So here I've tried to classify more or less because it's much more complicated than just putting countries in 3 different bubbles. What is the level of protection in ASEAN countries? Whether it's the super high protection of the Geneva Act, which of course is the one of Cambodia and EU, who are member of the Geneva Act. Japan also has this system. And then the high protection, which is the one in place in Laos, Myanmar, Singapore, Indonesia, and the low protection, which is the one in place in Vietnam, Thailand, Malaysia, India, with still some complexities. So this is a raw graph, but it just shows, you see, how difficult it is to enforce geographical indications when you have different scope of protection in the countries in the same region like ASEAN. I will just give you some examples about what does it mean concretely to have this heterogeneity of scope of protections, of level of protection. Of course, the various uses, and we already heard of those words before, so it's either the direct use of the geographical indication, what Mr. Bellatore has called usurpation. It can be just imitation or evocation of the geographical indication. There's also some uses which are prohibited when the GI is used for different type of product than the one designated by the GI, and also what are the uses authorized when the GI product is used as an ingredient in a more complex food stuff. And here, of course, geographical indication means the name. We are protecting the name. So here, just a simple table showing that the direct use of the GI is prohibited in all countries having the Lisbon system or the TRIPS additional system without having to prove any risk of misleading of the consumers as to the origin. What is the level of protection in the TRIPS basic standard? So depending on the countries, you have this need to prove that the consumers are misled or not, which is quite a different evidence to bring. So here, just one example from France. There's a geographical indication or a PDO, appellation of origin, on a cheese. And the specification provides that the milk production, cheese making, and refining of the cheese must be in that same geographical area. And the frauds department found out that there was a cheese using the name Charolais for cheese refined outside the area. So this was prohibited and there was a sanction. Same against any trademark application. So here's the case from Vietnam, geographical indication registered in Vietnam in 2005, brown Matruot coffee. And then the trademark was registered in China in 2010. It's a direct use of the GI name, same name, brown Matruot. So finally, the trademark was cancelled in China following the action of the Vietnamese local authorities, the province of Dak Lak. Now, if we look at a different country, which has not the high level of protection, so here the case was a product sold in a supermarket in Thailand, and feta is the name of geographical indication, where here again a PDO, denomination of origin, from Greece, which is for cheese made out of sheep milk. And here in the packaging, you see that actually there's an image of a cow, and you have in quite big letters mentioned product of Thailand. So here, this use might not be prohibited in Thailand because consumers are not misled about the origin of the product. They know that it's coming from Thailand, and they know it's made out of cow milk because of the pictures on the packaging. So here actually, because we are in the TRIPS basic protection, low protection, the direct use of a geographical indication is not prohibited if there's no confusion of consumers, which is a very hard evidence for producers to bring in front of a court or by sending a report to enforcement authorities. So that's the consequences in terms of heterogeneous scope of protection. Now, besides direct use of the GI, you also have imitation and evocation of the GI that are prohibited. This is the case for the TRIPS additional protection and the Lisbon system, where any imitation, evocation, misuse is prohibited, even if you use the name in translation or if you add style, type, method, whatever. This is not prohibited for countries having only the TRIPS basic protection. So just one example, which is from Italy, again, a cheese, where many GIs are on cheese actually in Europe. And here you see the trademark was Gorgonzola, which is different from the name Gorgonzola, which is the PDO registered, but it's an evocation. So that was prohibited, even though there's no risk of confusion of the consumers. That's the powerful tool of evocation imitation. So even if it is not directly the use of the name, but an imitation, that will be prohibited. And there was one case from Singapore, Mrs. We informed me about that case, thank you very much, about an application for trademark champagne wine. So it is not exactly the name champagne, it's an imitation of the name. And that trademark was applied for sparkling wines from Chile. There was an opposition from the Champagne Producers Organization and the French National Authority for Geographical Indication, INO, and the Intellectual Property Office of Singapore rejected that trademark, also because it was applied in bad faith. So here also imitation of a GI is prohibited in Singapore, which has the high level of protection. But in other countries, that is a picture from the US, actually you see that here it's the trademark Basmati, and it's mentioned Indian style Basmati rice. So Basmati is a GI from India and Pakistan. It's a complicated story, but at least registered in India. And here the use of Basmati, imitation of Basmati, was for rice grown in the US, in Texas. Well, that should be prohibited in countries having the high level of protection, because it's an imitation and even it's an evocation, imitation, and even if you use some indication Indian style, that is prohibited. But in countries who have the basic level of protection, this use might not be necessarily prohibited, because on the back side of the packaging, it's written clearly what is the origin of the rice, so it might not mislead the consumers. And but I will go fast on this, depending on the countries also, you have the protection of GI for dissimilar goods. This is the case in countries who have the Lisbon-Geneva system. So here, just one example from India and Taiwan. So Darjeeling is a famous geographical indication from India, and it was registered as a trademark for women underwear in many countries. And actually in Taiwan, the Supreme Administrative Court rejected the trademark Darjeeling, even though it was for completely different product, women underwear versus tea, because it was using the reputation of the GI Darjeeling. And last issue, depending on the country, you have different systems of protecting GI when the product is used as an ingredient. I will not go too much into detail because I think we run a little bit after time, but just here there was a case about champagne, and the name champagne could be used in sorbet because the taste of that sorbet was really influenced by the champagne ingredient. So that was for the scope of protection, which has shown the diversity depending on the country. So it will not be the same uses that will be prohibited depending on the countries, which makes life difficult for enforcement agencies, especially at the international level. If we look indeed more into details now at who are the actors and what are the actions of enforcement in countries, this is a general figure. And depending on the countries, it might change a little bit, depending on whether you have the ex officio, for example, protection or not. But you see, you have three different actions. One is the control on the market. So of course, this is the main role of the market control authorities on the domestic market and also at the borders, with the very powerful tool of detention of goods at the customs, which might exist or not, depending on the countries. Then in this control of the markets, the intellectual property or GI authority can provide some expertise about what is exactly infringement, what is the scope of protection, and the role then of the GI users and the management authority, whether it is a collective organization of producers or a local authority, can send also alerts or reports to the market control authorities. There was a question previously for Mr. Belleter whether they only act following alert or not. So depending on the countries, the market control authorities will act on their own, what we call the ex officio, or will only act following some reports and alerts sent to them by producers or by other authorities. That's really a country by country situation. What is important is also to see is that those control in the markets will finish by administrative sanction. So it will be administrative sanction of the fraudster, but no compensation for the GI users. If the GI users want to have any compensation or remedies, damages, then they need to go for a legal proceedings in front of courts, whether it's civil or criminal courts. So here, depending on the country, the market control authority itself can send a case to the public prosecutor. This is the case in Europe, in Italy, not necessarily the case in all the countries, but it's very useful because then they can immediately file a case in front of the courts. Depending on the countries, also you can have the intellectual property or geographical indication authorities supporting the plaintiff, being together next to the producers association, for example, in the courts, being co-plainants with the producers organization. That's the case in France. And of course, those legal proceedings are mainly the action to be taken by the GI users, the GI beneficiaries, and the management authority. And here you can get compensation and remedies for the damages due to the frauds. Then the last action is the surveillance of trademark applications. And that's the main role of the intellectual property authorities to really examine trademarks. They can reject on their own. So that's also a kind of ex officio action. The intellectual property office can reject on its own trademarks that do infringe the geographical indication. So again, according to the scope of protection of the country. But usually what is more often happening is that the rejection will follow an opposition by the GI users, the management authority, which means a very important activity of the GI producers organization in terms of surveillance of trademarks applications worldwide. And then the sanction, of course, is the refusal of the registration of the trademark. Just now some examples. I will still say a little bit about Europe, which is that there's the ex officio control, and also besides all what Dr. Belleter has shown about the cooperation between enforcement authorities, recently the Observatory of the EU IPO has developed the enforcement database, especially for customs and police, so at the borders and on the domestic markets, to support them in their role of inspection and deciding whether it is an infringement or not. So this enforcement database is available for all the intellectual property right holders, not only for geographical indications, with information as to who are the right holder, what is, of course, the right protected, and you can have the name of the GI, some short summary about the content of the GI specification, some pictures of what are the packagings allowed, if there are very strict rules for the labeling and the packaging, etc., etc. So this database is really useful because it's difficult for all enforcement authorities to know for each geographical indication what is authorized and what is not authorized and who to contact. So that's a little bit similar to the Amazon web page that we saw before, when you have all those details, really helping enforcement authorities to check easily what are the rights and the rights holders. Just here some one slide about the French situation. So it's the Directorate General for Competition Policy, Consumers Affairs and Fraud Control, DGCCRF, who is responsible for carrying the checks for any kind of products, food products, but also non-food products. It's under the Ministry of Commerce and Finance, so it's a bit different from the system in Italy, which is under the Ministry of Agriculture. And the check will be done at any stage of marketing, including on the internet. And the breaches are the GI, use of the GI for non-compliant product, lack of traceability documents. That's a very important breach that is often sanctioned by the enforcement authorities. Traceability documents are missing, and the lack of use of the EU PDO-PGI logo, which is mandatory for countries in the EU. So just here, one figure from 2017, there were 200 GIs which have been checked, and including 40 from EU or third countries. So you see here, I've put in black Cambodia. Actually, the French Repression of Frauds has done a lot of inspection of compote paper in the French market, which is the main export market of compote paper, because there's been some suspicion of frauds. So they are doing those checks on their own without any reports sent by the producers' organization or the competent authority from Cambodia. DGCCRF is really doing the checks on their own. And also, of course, if there's a report, they will do the inspection. So they are working on both sides, on their own and following reports. And here just have some statistic about the numbers of establishments that were inspected and the sanctions. Now let's look at some countries in Asia. So in particular in Vietnam. So in Vietnam, there's a very strong policy to fight against frauds of intellectual property rights, against infringement. And we talk more about infringement when it's on intellectual property rights. And with a very active, strong policy, in particular, there was a National Steering Committee, which is called 389, which was set up for fighting against smuggling, commercial frauds, and counterfeit goods. So this committee tries to coordinate the various enforcement agencies, which are numerous. You see that there's one enforcement agency, which is the Inspectorate under the Ministry of Science and Technology. In Vietnam, actually, the National Office of Intellectual Property is under the Ministry of Science and Technology, but we have someone from NYP just after presenting who can give some compliment about this. Then another authority is the Market Surveillance Agency, which is under the Ministry of Industry and Trade. They will do a lot the inspection on the domestic market at the local level. Then, of course, you have the Department of Customs under the Ministry of Finance, which is doing the anti-smuggling investigation, which goes beyond just infringement of intellectual property rights. And finally, the Economic Police Department under the Ministry of Public Security. So quite a big amount of enforcement bodies that try to coordinate to be efficient in checking the marketplace at the domestic and at the customs levels. And the coordination is strong with NOIP, especially to clarify what is the content of the protection. That's always a complex issue to see what is authorized, what is prohibited. When it is a direct use of the GI, it's easy, but when it is imitation, it's much more complicated. And NOIP, of course, on its own also has this surveillance of, when they examine trademark application, they will also reject trademarks which are infringing geographical indications. So there was a recent case, the trademark Glen Silvers for alcoholic beverage was rejected by NOIP because it's connected with Scotland and therefore infringing the geographical indication Scotch whiskey, which is registered in Vietnam since many years now. So the NOIP is very active also in giving this expertise in terms of intellectual property and opposing trademarks infringing geographical indications. If we look at another country in Asia, it's Cambodia. Here, without presenting all the system in Cambodia, I would just like to highlight on a particular action of the Cambodian government regarding the compote paper GI, which is a very successful GI, but a lot of frauds, a lot of misuses of the name. So the government decided to set up a specific committee of infringement of compote paper in the domestic market. That was presented by Mr. Laurese last week. And well, the activities have just started. And this committee gathers the Directorate General from Department of Consumer Protection and Fraud Repression, the Economic Police, and the Provincial Department of Commerce from the province where paper is cultivated. And of course, it includes the Directorate of Intellectual Property under the Ministry of Commerce. So here they have really set up that committee to tackle this issue of massive frauds of compound paper in the domestic market. So that's a good, first policy to really empower, people with the issue of enforcement. And then one example about Singapore. So it will be probably more presented with more details by Mrs. Wee Yin. So Singapore has signed the FTA with Europe. And following that FTA, the GI Act of 2014 was passed. And there's a quite amount of article and provisions about the role of customs in enforcing geographical indication in doing inspection and check of suspected infringing goods. So here there's this particular action of detaining suspected infringing goods, which can be asked by producers or association of producers and also by traders. So it is quite interesting to see that here you have an action that traders can lodge, in front of the custom, and they can ask the custom to seize the goods, to detain the goods. So even the traders can have this action, which I think is quite interesting. Now, I would just like to stress out some common challenges in ASEAN countries regarding enforcement of geographical indications. First, one of the main challenges is that there is limited awareness of right holders and consumers about what is infringement. Not everybody knows there is a geographical indication, and then not everybody knows what is the authentic product and the fake product. There's quite lack of awareness and knowledge on this. But what is also a bit striking is that actually from interviews conducting with enforcement bodies in Vietnam 2 years ago, there was some reports that finally some right holders, so for geographical indications or any other intellectual property rights, had limited willingness to fight against counterfeits because they were a bit scared that this would damage their reputation. If you fight against counterfeits, if you lodge a legal action especially, it means that you are afraid there is a lot of fake products in the market, and so it puts into danger your own products. And this is easy to understand that it's very difficult for producers' organizations to put this in the light that they have issues with fake products circulating in the market. And even looking at the consumer side, sometimes consumers are not always interested by looking for the authentic product. They know that there is a copy, they know there are some imitation, and they're even searching for cheap imitations of the authentic product. So that's also here a big challenge to really raise awareness that, okay, you can have imitation, but they can just use a different name. The idea is not to have only the GI product in the market, but the imitation, the low quality product, just be another name. Looking at another issue is the expertise of enforcement authorities. It's quite complex. We saw with the examples of what were the uses prohibited or authorized depending on the countries. And it's quite more complex actually if you go into details of each national legislation. So it means that all the enforcement agencies need to have this expertise about what is geographical indication, what is the content of the book of specification, what are the uses prohibited. And the same for the judicial courts. They also need to have that expertise when giving a judgment about a possibly case of alleged infringement. So here was just one example of training that has been organized. That was for Vietnamese officers of the Market Surveillance Agency. They were trained under a program run by the French Embassy together with the Champagne Producers Association, who tried to explain better what was the authentic product, to facilitate the task of enforcement agencies when checking the fake champagne. So those officers were even invited to come to France, and they visited the Champagne area to really understand the product. Well, that is difficult to do for the 3,500 GIs registered in the EU, for the more than 400 GIs registered in ASEAN countries. Well, at least maybe for GIs in Vietnam, it's easier for the enforcement agencies, but that's a way also for those officers to better understand what is the product and what are the uses authorized or prohibited. Then another issue about this, facilitation of enforcement officers and to facilitate the knowledge, the understanding of what needs to be controlled. It's really important that the GI specification itself is written very clearly. And we say that a lot for controlling the product before putting the product into the market, that the specification has to be very clear. Then the controlling body, the certification body can easily do the check and inspection on the farm. Actually, that's the same issue for controlling geographical indications in the market. And just here, we're getting one example from Thailand, this Lampung Brocade Thai silk. When you look at the GI specification, it's not extremely clear which steps of production are mandatory in the geographical area. Is it only the weaving of the fabric of the silk, or the sericulture is also mandatory? And the clarity of specification is really necessary for having, producers understanding, of course, the specification, but controlling bodies also being able to control what is in the specification and what is authentic product, what is fake product. What should be, of course, very useful is to have at the level of ASEAN enforcement database with all those information gathered in one single place, available for all the enforcement authorities through ASEAN. So there's already an ASEAN GI database, which is gathering some information about GI registered, while it's not fully updated. So that would be really useful to have an update of this database. And maybe, of course, mentioning what is the name of the GI, but also what are the labeling rules. Also giving some abstract of the GI specification, the contact of the right holders of the GI Collective Management Association, and maybe some information about the level of protection in each country to make things easier for the enforcement authorities. That will be, it's difficult to set up, but very useful to support officers doing the checks and controls. And then the last point is that actually in ASEAN countries, there are very few cases handled by courts. The jurisprudence is very, very small for geographical indication. So it's mainly administrative action that is taken against infringements. Of course, it's cost effective and time efficient for GI holders or intellectual property right holders, because it's all taken, all paid by the administrative authorities. But then the penalties, the sanctions are not as severe as those available in civil litigation or criminal prosecution. So there might be not enough to really stop infringers, doing the fake product, because the sanctions are too weak. And regarding the cases handled by courts, it's quite expensive for GI Producers Association to file a case in front of courts. Then, of course, the difficulty also is the long duration of the litigation process, the unpredictable outcome. We never know exactly what will be the decision of the courts finally. And regarding the damages and remedies, it's always difficult to calculate those damages. So it's quite a burden to go for courts in case of infringement. Then one option should be maybe to have specific courts dedicated to intellectual property infringement, including geographical indication. Well, and my conclusion, I hope I haven't been too long, that it's very, of course, important to fight against frauds to protect the reputation of the GI. It's not yet fully included in the ASEAN Intellectual Property Right Action Plan. Another issue is whether there is any objective of having an homogeneous level of protection for geographical throughout ASEAN countries. And we saw there's a lot of diversity, scope of protection. Is this going to change in the coming future? Again, the control should not only focus on products bearing the product logo or national GI logo, but also the products only using the name. It's much more work for the enforcement authority, but that's really the concept of geographical indication and to control the name. Of course, the importance of state agency, how they can coordinate at national, regional, and international level. We had this example in Europe. How can that be implemented in ASEAN? And finally, also how to strengthen the cooperation with the GI right holders. And here it's really important to have also strong collective management organization that can be active in doing some reports about frauds of their product in the market, because they are the one who know the market, they know the buyers. So they can also have a very active role in surveillance of the market and sending reports.